Good morning. Welcome to the Public Safety Committee meeting. Today is Friday, January 13th, Friday the 13th, 2012 at 8:30 a.m. I am joined by my colleague Dennis P. Zine. And there are a lot of speaker cards. We've got 3 pretty full agendas. I wanted to let you know that without a quorum, we are not to host and have public comment. So unless we have 3 members of a 4-member committee, there is no public comment. Having said that, there is always an opportunity, so you know, for public comment, either in this committee, if things come back to this committee with a quorum, and if not, when they go to the full city council, they will be required then, since we didn't fulfill public comment, because by law, public comment is not considered public comment at all without a quorum of the committee. So I wanted to let you know that for those of you who are here, who woke up early this morning to get here and fill out speaker cards, unless another member shows up. Having said that, we're going to go ahead and start on the first agenda items and move items 1, 3, 4, 5, item 6, item 7, item 9, item 10, 11, and 12 on consent.
Well, I have questions on 2, 5, 6, 7, 8, 9.
You have questions on those items.
2, 5, 6, 7, 8, 9.
But I appreciate that, Mr. Zine. We do have a pretty full agenda. The only issue with those questions is it's a consent from the chair, since we don't have a quorum. So unless you want to table those items for another meeting, for a quorum, I suggest we just move them on to council and we can ask then.
I want to ask now, so I'm here as a member of the committee to ask the questions that I have. We don't have to wait to do it in the council. We could probably do it rather quickly, but there's some simple questions on this particular item.
I will entertain that. What's rather quickly? Just a quick questions?
5 minutes.
5 minutes? You got it. All right. The items were?
2, 5, 6, 7, 8, 9.
Items 2, I did not move on consent. 5, 6, 7, 8, I did not move on consent. And 9.
The rest of my head, no problem.
Okay. Do we have a representative from LAFD here that can speak on items 5, 6, 7, and 9? Those are donations of a barbecue. We'll take all those together. The tools, an ice machine, and a $2 million STEP grant.
Pardon me?
You have question number 3?
No.
Number 3 is approved.
Okay, 1, 3, 4, 10, 11, and 12 are then moved.
Thank you.
Morning. You could just state your name for the record, tell us who you are, and we'll go ahead and go right to the questions on those items.
Good morning, Glenn Miyagishima, Battalion Chief, Los Angeles Fire Department.
Chief, on question number 2,
Thank you.
the proposed fee for the plan review.
I'm sorry, 2 was not up yet,
Oh, 2,
and it
all
was
right.
not moved on consent, so we're going to take
So
that
let's-
separately.
Let's go to.
So item 5.
5, 6, 7, 5, 6, and 7. On 5 is station number 10, and we want to appreciate Mr. Neeleman. How do we express our appreciation for this generous donation he's doing?
I'm sorry, sir, can you repeat that?
Mr. Neeleman, who's donating $6,137.66 for a barbecue at the station number 10 on item number 5.
Yes, sir, Mr.
What does the fire
Zine.
department do to show appreciation for that very generous expenditure?
The generous donation came from Mr. Needleman, a supporter of Fire Station 10, and what he did is reached out to the members there.
I'm asking, how do we express appreciation to him? Do we give him a fire badge, a fire helmet?
Oh, I'm
Act-
sorry.
What do we do? How do
Yeah,
we show
we're
him,
gonna,
hey, we appreciate what you're doing?
Of course, he's been over to the fire station for lunch, but we're also gonna bring him over and commend him for his donation.
Okay.
We'll appreciate through the fire commission and put something together, a certificate on behalf of the fire commissioners.
But we just don't accept and say, we express our appreciation, which is my concern.
Absolutely, we will.
Okay. And on number 6, the chainsaw, I thought that some of those items were requisitioned through the city.
That is correct, sir, but what they're doing is, because Station 7 is a single-engine company and not a truck company, they don't have that type of tools on their apparatus, and to expedite an immediate response in using a chainsaw for a clearing brush or using a Hamas for a physical rescue, it's an immediate ability to start the emergency instead
So
of
it's
waiting for
something
a
that they would
truck.
normally get through the normal operation.
They would, but this would help Engine 7 start an operation immediately.
Okay. And then on number 7, the $18,000 expenditure.
It's a donation.
It's a donation from the Firemen's Fund Corporation, donating the ice machine, the equipment to facilitate physical fitness and comforts at the fire station, because ice machines are not a product of the city. So it's a donation from the funds.
And the exercise equipment's not either?
No, all exercise equipment within the fire department is donated or accumulated by the individuals through house dues.
Okay. I know that we do fundraisers. They have the event downtown, Hope Street, I think it is.
Yeah, Hope for Firefighters.
Then we have one in the valley in my
Yes,
district.
over in your district, sir. Yes.
Those dollars are then appropriated for items like this in the future?
They have been in the past, and they could be in the future. This is a specific donation from the Firemen's Fund Insurance for Fire Station 88.
And we will then express appreciation to them also for their
Absolutely,
generosity.
always.
Okay. I just want to make sure we thank these people for
No, we won't.
doing that type of generous donation to our firefighters.
Absolutely, sir. We'll make
Okay,
sure.
that's all I had on
Okay.
those 5, 6, 7. Thank you.
You're welcome, sir.
And you say
Thank
8,
you very
9
much.
on the schedule, right?
I'm sorry?
8, 9 still on the schedule.
8 and 9 are still on the schedule. 9, I don't believe that anybody is here from LAPD to answer that question on number 9.
Okay.
So, having said that, we can bring that back, send it to council, or hold it on the desk.
There's the issue that I have is driver's license checkpoints, and I didn't think that they were doing driver's license checkpoints, and that was the question. This grant for $2 million applies to DUI checkpoints, or DUI saturated patrols, DUI checkpoints, and driver's license checkpoints. So my question was driver's license checkpoints. I was under the impression that they weren't doing those anymore. And that's why I want to find out if we're getting $2 million for something.
Well, they're still doing the DUI checkpoints.
Well, it says DUI checkpoints.
So we
but
could.
It also says driver's license checkpoints.
Well, when the grant, I believe, was applied for, reading the notes in the staff report, we were. And then as of January 1st, we are no longer. But we're still doing the checkpoints. So we can bring that question up to council as well.
So that should be modified at that appropriate time.
Ask that question, yes.
Okay.
Okay, so we'll go ahead and move those items then.
Okay.
As approvals, 5, 6, 7, and 9.
Recommendation? Yes.
Thank you.
Now we'll take item 2, and if we can have representatives from LAFD on items 2.
Item 2, Board of Fire Commissioners and CAO reports relative to proposed fees for the plan review, inspection, and testing of fire hydrants, fire access, and fire flow requirements.
Morning, gentlemen. How you doing?
Good morning, Chief Kerbrat, Technical Section Commander.
Mark Davis, CAO.
So walk us through this, and are these new fees that are being proposed? Have we ever charged these fees?
Yes, those are
prior?
new, yes, those are new fees. What you have proposed in front of you this morning is some additional fees for our plan checkers to review hydrants, where they're located, field inspection of those hydrants, access issues that are associated to new developments, field inspection of those developments, and also our input on the initial stages of environmental impact reports when developers come to the city of Los Angeles.
And a few questions on these. These are charged then to whom are these fees charged to? And who is the keeper of time and who bills the recipient?
Yeah, these are
Process.
these are charged directly to the developer, the way it's processed, because we don't have our own cashiering system over at where our location is. It's collected through the Building and Safety Department. The Building and Safety Department collects those fees on our behalf and then transfers it over to the fire department for their accounting.
And are there any other cities that you're aware of that are charging these fees to developers?
Probably about
If so-
90% of all the, almost every city that I've surveyed has charges for these fees. Sometimes, most of them do them through their fire departments, other do it through their water departments, and other do it through their planning departments. But the service is what all the ones that I surveyed, and I surveyed about 10 other departments
Right.
that charge for these fees.
Okay. And who installs the hydrant?
In the city of Los Angeles, the initial request for the hydrant comes from the fire department. The fire department says, hey, we need this as a, for this building, hydrant to protect this building. And then we pass that responsibility or request on the DWP. DWP, in turn, puts it in. So DWP does it, then they take ownership of that hydrant as soon as that
DWP
occurs.
installs the hydrant?
Yes.
Do they charge a fee for the installation of the hydrant?
The developer will have to, depending on the impact, but the developer will have to pay for those new hydrants as well.
So they're
Aside from these
they're
fees.
doing that now, they're paying?
They're doing that now.
And DWP is billing them for the installation of the hydrant?
That's correct.
But that doesn't, are we positive DWP is not including any inspection fees as part of that installation already?
This inspection fee is separate from that, as those fees have never been collected before, for that work that we were doing in the
Yeah,
beginning.
my question though is, we're certain that DWP is not charging any inspection fees as part of that installation process?
They're not charging any inspection fees as part of that installation. They're doing simply the installation part.
Okay. And then is this cost recovery?
This is cost recovery. That's what the fee's based on. It's based on an hourly rate, inspector full cost hourly rate.
Is it full cost recovery?
It is full cost recovery for those specific time frames that they provide those services exclusively.
Because that was where my question came in. It says that it's only a 40%
Right,
of full cost, not full cost.
right, because that's not what all those inspectors do. This is 40% of what they do, and that's explained in the document. 60% of what they do has to do with their relation with other agencies, how they work with environmental impact reports in the planning department, how they work in case management, their liaison with DWP, their infrastructure, look at our water systems. Those things are not recovered at this time. Our intent is to look at those and see if there's opportunities for those services too to be recovered, for the city to recover costs for that.
So how we've come up with the fee structure is we took their full cost in time, including cap costs,
That's correct.
and said, well, 40% roughly of their time is spent on this
On these
process.
services.
Therefore, we're going to come up with the total cost of that unit, take 40% of that cost, break it down by hour, and that's how we came up with the fee.
Precisely.
I would ask that we revisit that, because on that scenario, if they spent 100% on the time, that would equate to $400 an hour. And the fees starting at $156 an hour all the way to $312 for 2-hour minimums seems excessive, because what we're, in fact, what we're doing by coming up with that calculation is charging 100%, not of the total unit, but of their totality of time. In other words, we've taken 100% of their time, come up with a dollar price, and then we're charging only 40% of that to the developer, where it should be only based on that 40% of time it should be in essence 40% of that fee. And this is 100% of the 40% time. So in other words, $156 an hour, we're not paying them $156 an hour, are we? Is that the cost of the actual firefighter that's spending the time on inspections of plan reviews, field inspection reports, as well as the fire hydrant review? Is that what it's
No,
costing us, is $156 an hour?
Yes. What happens is, in the city of Los Angeles, they come up with a rate based, what the inspector rate is. The inspector rate is just a small portion of that cost. Another portion of that cost is his benefits, the inspector's benefits. Another cost is the overhead costs. There's 3 overhead costs, cap costs that have to do with department overhead. The other part has to do with city cost of services. Those are all incorporated into that hourly rate.
Right.
So we take his hourly rate, it works out to 156 hours. That's what it costs to put him on the street per hour. We're only charging him for 40% for the work that he's actually doing for that contractor. We're not charging him for the rest of the year. He's not buying into anything else they do for that year, just for the services that are provided for that time.
But that's my point, is we're charging the 100% of the hour time, $156 an hour, if that's what the cost is.
That's what the cost is
Right.
for
if
that
we-
service.
If we could have a breakdown when this comes to council on the analysis on how we got to that figure, I think.
On the hourly rate,
On the hourly rate,
okay?
okay, and that would be great.
We can forward it to you.
Mr. Zine?
Just on the 156 to the 312, are there current, you got proposed fees, are there current fees that compare to what we're currently charging on any of these, the review fee, et cetera?
Yes.
You got proposed, but it doesn't show the current.
Current fees in the hydrant?
To correspond with this, so when it comes to council, you can also show
Yeah.
proposed, current, and then what the proposed are, so we'll see the difference.
Okay. All hourly rate for all services provided by the fire department, an hourly rate is $156 an hour.
Okay.
Okay, that's the current rate for all services that we provide. These are just 4 more new services that we'll provide.
The six items listed here.
Right.
And the question I have is, what are we charging currently? Either we're charging nothing or we're charging
And the
something.
answer is nothing.
So on all 6, there's currently no charges at all.
That's correct.
So what this would generate is $409,000
For these services that we've been doing that
For a full year.
for the full year, during the full year.
Okay. That's the question.
Okay, so we'll go ahead and move this item as approved to council as well.
Thank you.
Thank you.
The next item on your regular agenda is item 8. Motion Parks Labange requesting that the police department and the city attorney report relative to the department's...
We're actually going to hold that for a minute
Sure.
and go over to special first.
Okay. Special agenda has 3 items, all concerning medical marijuana, city's policies regarding.
And we'll take all those 3 together.
Okay.
And I believe we do have city attorney as well as Councilman Huizar in the room.
Okay.
And then we'll have, since we have the councilman, I wanted to take that item first, out of respect for the councilman who's here and not on the committee, but visiting the committee, and we appreciate that, and he's the mover of the motion. And so if we could have city attorney as well as Councilman Huizar at the table, that would be great.
Good morning.
Morning.
Good morning, council members, and thank you for taking this item up today. We appreciate it. As you know, we are here to hear a motion that asks, in the motion, for a repeal and ban of our current ordinance as it relates to medical marijuana facilities, dispensaries in our city. I'll just give a brief overview and why I decided to move that motion forward. And obviously, the city attorney's office is here to speak in more depth about the details of our ordinance and the legal issues involved with medical marijuana as it pertains to the city of Los Angeles. As you know, back in 2007, when the city took up a discussion about what to do with the emerging medical marijuana dispensaries throughout the city of Los Angeles, some say there were about 700 to 900 dispensaries in our city. We crafted an ordinance that took us some time, and the purpose of the ordinance was to provide a balance between allowing access for medical marijuana patients and those who need it, and on the other hand, control for the ill effects of some of these dispensaries that spill out into the community, such as young people having access, smoking it on people's lawns, and other ill effects in local communities. And those, the way we did that was by having a cap. We were going to do 100 dispensaries throughout the city. We hoped to keep them away from sensitive uses such as churches and schools and other facilities like that. We hoped to keep them certain distances from one another so we could prevent the overconcentration in any particular neighborhood. Unfortunately, this past November, in a case that we refer to as PAC, found the Long Beach City Council, which ordinance with respect to medical marijuana unconstitutional. That ordinance is very similar to the one in the city of Los Angeles. And what that effectively did was to take away our ability to balance on the side of helping to control for the ill effects and impacts on our local communities. And my concern is if we move forward as we are now, we will be back into pre-2007 era where we have no ordinance to enforce, and when we will see these dispensaries pop up all over the city once again. Now, I want to make clear that I personally believe in the use of, and the value of medical marijuana for patients who truly need it. But if we are put in a situation like we are today, where we have no tools at our disposal to control for the ill effects of that medical marijuana on dispensaries, on local communities, we have no other option but to repeal our ordinance, ban dispensaries, and wait to see what happens in the California Supreme Court case when that is taken up. It is a very difficult decision that I came to because, like I said, I truly believe in giving patients the ability to have access. But at the same time, many of these patients can still have access if they follow what the state law provides for us, which is they can grow their own or they can be provided by their caretaker. And I think that is the right route to go. There are many dispensaries that do well, that are following the rules. At the same time, there are many dispensaries who are making hundreds of thousands of dollars off of this, when in fact they should be nonprofits. And given the money that is to be made, I predict there will be a number of these dispensaries pop up everywhere if we do nothing. So thank you very much for taking this up. I have another commitment at 9 o'clock. I will leave the room, but the city attorney's office, who I think is doing a spectacular job given the circumstances, conflicting laws with federal, state, and local level, they have done a great job to protect the interests of the residents of the city of Los Angeles, and they have and are perhaps even more knowledgeable than myself on this issue with all the legal issues and everything else. Thank you.
Thank you. Thank you, Councilman. We'll go ahead and turn it over to the city attorney. I was also going to ask immediately after the city attorney if Captain Murphy was here from LAPD that can give us some of the information on what's been happening as well as what Councilman Huizar alluded to immediately after the city attorney's report. But with that, let me just say this is a very difficult issue, and it's complicated for many reasons. And as one of the things the councilman just said, there are a lot of people out there that rely on the effects of and the benefits of marijuana that are dealing with cancer and other ailments. But looking at what it's done to communities, I mean, I think at one point I'd read in the newspaper, not that I believe everything I read in the newspaper, but I had read in the newspaper that we had more medical marijuana facilities in the city of LA than we had ice cream parlors. And one of the things that they do to communities and knowing, and as a police officer myself and seeing firsthand what they've done in some of the situations, not necessarily the operators, but the patrons, is causing a lot of effects as well. So we've got to balance that. I do want to remind everybody that because this is sensitive, this is the Public Safety Committee of the City Council. We don't have a Public Health Committee of the City Council. And the reason is because public health is not under the jurisdiction of the Los Angeles City Council. That's under the county jurisdiction. And so as it pertains to arguments of public health, that is not under our purview. While I'm empathetic about that, we do have that under the county. And so there are issues there. We're looking at this from strictly in this committee, and I'm going to ask the city attorney to weigh in, and if this matter was not scheduled for any other committee, should it be? And with that, we deal with zoning issues, and this is a zoning issue as well. But this was really a matter of public safety as it pertains to the Public Safety Committee. So with that, if you can give us an update on where we are with the court cases, what are your recommendations as it pertains to the 3 motions that are in, what are the next steps, what would you like to see this committee do from a city attorney perspective to cover the liability of the city, to cover the current court actions, to cover any possible civil liabilities, to ensure public safety citywide.
Good morning, Chair Englander. Good morning, Councilman Zine. Jane Usher in the City Attorney's Office. Let me introduce Steve Blau, who's sitting to my right, City Attorney. Asha Greenberg sitting to my left, City Attorney. Steve is the principal who handles the more than 60 lawsuits. I'm going to say that again in case we missed it. More than 60 lawsuits with nearly 200 litigants filed against the City of Los Angeles by medical marijuana dispensaries and in some cases patients. Asha Greenberg is responsible for enforcement, and so, Chair...
The enforcement team?
OSHA is responsible for the city attorney's enforcement actions against unlawful businesses, nuisance abatement, and the like. She is the ground central for complaints against medical marijuana dispensaries, so she's with us this morning to speak to the complaints that she's received.
How many are in that division?
I hate to tell you because I wish I could tell you there was a battalion. It's a really small team.
Okay.
We are here largely because of something that happened on October 4 of last year. On October 4, the appellate court that governs this region took a legal step that dramatically shifted the landscape for medical marijuana dispensaries. You've heard Councilman Huizar refer to the PAC, P-A-C-K case. It dramatically shifted the legal landscape, and it is why we are here today. That court determined that cities cannot affirmatively authorize medical marijuana dispensaries because to do so conflicts with and is preempted by the federal law known as the Controlled Substances Act. In that opinion, the Court of Appeal was looking at the City of Los Angeles' ordinance, and you should know that the City of Long Beach's ordinance. Long Beach modeled their ordinance after your own. So Long Beach took the City of Los Angeles ordinance and made some modifications, so we largely have the same ordinance as does the City of Long Beach. Accordingly, the PAC decision pertains to us in full force. It is inescapable. The PAC court said, among other things, that a lottery was not appropriate. It was preempted by by federal law. They said that a cap was not appropriate. A cap is preempted. They left very, very little for cities to lawfully do, and that decision is currently pending before the California Supreme Court, who will decide by February 8 whether to review that conclusion, the conclusions drawn by the Court of Appeal in PAC. But our 60 lawsuits, Chair, our 60 lawsuits and 200 litigants, they continue. They proceed. They are not abated or stopped by the PAC decision, and they do not wait for the California Supreme Court to either consider or decline to consider PAC. Let's look at the timetable that we face from a risk management point of view, because surely that's one of your charges. From a risk management point of view, we can all anticipate that if the California Supreme Court takes up PAC, we will have from 6 months to a year before that case is decided by the California Supreme Court. And in that interim, we will continue to litigate our more than 60 cases. The nearest term action, the nearest term case that we face is on January 31 of this month. On January 31, we will be before our trial court on a motion to reconsider our own ordinance in light of the PAC decision. It is simply a matter of time, council members, from a risk management point of view, before we have a ruling against the City of Los Angeles' ordinance on the same grounds as were determined in PAC. It's simply a matter of time, in our opinion. As a result, as much as the city might like to wait for the California Supreme Court to conclude its consideration.
If you have cell phones, can you please put them on silent, or if there's too many people in the room, I just don't want the interruption. I want everybody to be able to hear this. If you could step outside to take any phone calls as well.
Thank you so much. I appreciate it.
Thank you.
In any event.
I better check my own.
Okay. It would be very tempting for the City of Los Angeles to say, let's wait. Let's wait until the California Supreme Court has concluded its thinking about the PAC case. We are here to let you know that that is not an option for the City of Los Angeles due to the 60-plus cases that we continue to pursue and defend. So here we are telling you, you have an ordinance on the books concerning medical marijuana, and your ordinance is not implementable. We cannot go forward. The very first step of implementation in that ordinance is to determine who's grandfathered. The very second step is to hold a lottery. Neither of those actions are permissible under PAC. What do you do in the face of 60-plus lawsuits and an ordinance that cannot be implemented? We see only one conclusion. There is no other responsible legal option. What you must do is you must repeal the current ordinance, and the swifter that action is taken, the better. In addition, we recommend what we call a gentle ban. We are proposing a ban of medical marijuana businesses, and I underscore that word, businesses. We are proposing that you ban the transactions that are occurring that are beyond state law's provision of medical marijuana for seriously ill patients. Our gentle ban does not look like the other bans that you will see and hear about that the courts of appeal around the state have sanctioned. Ours has several paragraphs wherein the City of Los Angeles says, we will accept certain things from the ban. And without reading them chapter and verse for you, the essence of those exceptions is to allow seriously ill patients together with their primary caregivers to engage in cultivation. So let me repeat, your only option is to repeal your unenforceable, unimplementable ordinance. Your second step should be a gentle ban. Why? And here is where I conclude. There are concepts in law. We don't have the luxury of going into closed session today because we don't have a quorum. We'll certainly do that at full council. But an argument that has been made in our cases, our 60-plus cases for the last nearly 2 years, is that these businesses have achieved vested rights to operate in the city. And in October, our trial judge concluded that they have not. But that argument will not go away. At the end of PAC, whatever that decision is from the California Supreme Court, including its decline of review, the City of Los Angeles deserves an opportunity to write a lawful ordinance when the law has cleared. And today it is unfortunately very unclear, and we need further guidance from the California Supreme Court and potentially the California Legislature. With that, council members, I conclude my report. If and when you get to the point where you are ready to take an action, or more particularly since you lack a quorum, forward a recommendation, I would like to be very specific about what we would like you to forward.
Okay. With that, and I know this isn't the budget committee, but do you have an idea of the cost and litigation the city has spent either to date or anticipates spending in totality over these cases?
Well, I'm very disappointed, Chair, to tell you I'm sure we've spent in the millions because we have a team of lawyers, both in the litigation and in the enforcement, who have spent 2 years in court, certainly weekly, sometimes daily. And I can't imagine that you want us to be using the city's resources in that way, but because we are defending against lawsuits, we must, to protect the city from liability, we simply must.
All right, thank you. Appreciate that. And if you can give us an idea of your unit, if you will, and it sounds like you've got a full plate.
Yes, we do.
What's been going on? What kinds of complaints have we been getting? What has been your experience as well, and your recommendation from your perspective and moving forward as well on this?
Once the City Council passed the ordinance, which was in May of 2010, we set up an email address where people could send us complaints, and somehow people also got to know that I was the person to whom the complaints should be directed. So ever since then, we have become the recipient of complaints of all kinds from all over the city. And for some reason, lately, the complaints have just reached a crescendo. There seems to be a perception somehow in the city that dispensaries can open up without any consequence. And I'll just speak briefly about the types of complaints that we receive, and they involve a whole host of quality of life issues. They involve things like loitering and smoking outside the dispensaries, in parking lots, in public areas. We get complaints of secondary sales of marijuana where teenagers are waiting in parking lots, kind of similar to what happens with alcohol, where an adult goes in and purchases the alcohol or the marijuana and turns it over to a teenager who's waiting in the parking lot.
Are these isolated incidents or are these citywide?
They're not isolated. There are several complaints about the same kind of thing. We have lots of complaints about increased traffic, no parking spaces, and reckless driving by the customers. We have complaints about aggressive security guards. There was one complaint that I received from a neighbor of a dispensary who said that he was out walking at night and a security guard was so jumpy that he pulled a gun on him because he thought that he was going to rob the dispensary. We have reports of increased crime. There was one incident that was reported to us, which I don't even know if it was reported to the police, where burglars broke into this woman's office. She was a professional accountant, I believe, and cut a window in the wall of her office so they could access the dispensary. And we have complaints about proximity to schools, to libraries, to churches, synagogues, and parks. As to one school that was close to a dispensary, I received over 60 letters from irate parents because they wanted this dispensary gone. I recently heard about a dispensary that opened up right across from a police station. When the police went over there to talk to the dispensary operators, the operator said, well, we thought this would be a safe location for us to open up. So it's pretty blatant. There are also complaints about the dispensary's customers mostly driving away legitimate business customers. There was an operator of a store which I think sells rugs who complained that he had a very valuable long-standing customer who encountered some customers of the dispensary who were intimidating her and harassing her in the parking lot, and she said, basically, I'm never coming back to you again. From the very beginning, we started to receive complaints about the smell of marijuana, which was permeating neighboring businesses, especially if they shared the same ventilation system. And it's interesting because even my colleagues, one of my colleagues said to me one day, I went to get a foot massage and I was sitting there, I could smell marijuana. And I asked the person, where's the smell coming from? And she said, we have a dispensary next door. So there are people who are sick themselves who complain that they can't stand the smell of marijuana. There was one dispensary where the neighboring business had a pregnant woman who was working there. She couldn't stand the smell of marijuana, so she called the police to see if they could do something about it. A continuous complaint that we hear over and over again from people is that all the customers of the dispensaries don't seem to be ill, that they're all young and they seem to be perfectly healthy and going into these dispensaries. We have dispensary owners who misrepresent their tax registration certificates as permits and licenses to property owners, so that the property owners will rent to them. Even I've been the subject of misrepresentation. One dispensary owner forged a letter with my signature on it and put it up on his wall, and basically saying that he was authorized to do business. And it was a letter that had my signature, which had said that they weren't authorized to do business, but he photoshopped it and made it into something quite different. Another one told police that he had spoken with me, and I had said that everything was perfectly fine, when in fact I had never spoken to that person. So the bottom line is that these dispensaries are very lucrative, and we have become a magnet for materialistic opportunities who see them as just money trees. And it looks to me, at least from an enforcement perspective, that they're going to continue to open in the city unless we take some definitive action to say that they can't.
Okay, thank you.
Thank you.
Do you have anything to add?
Nothing to add unless you have any questions.
Okay. I did want LAPD to come up. Again, this is the Public Safety Committee, and for those who have come in late and filled out speaker cards, I had made an announcement at the beginning of the committee that since we lack a quorum, we can't legally fulfill our obligation for public comment. However, it is required under every item, and therefore, if we don't have a quorum, if this either comes back to this committee with a quorum, we will satisfy that. If it moves on to the full city council, that will be required then to have a full public hearing at a quorum of the city council. But a quorum is what satisfies public comment, and so therefore we cannot legally have a justified public comment which meets then that obligation. And so that obligation will have not been met, and so we'll be doing that at the full city council unless another council member happens to show up. And this is a 4-member committee, which means it's a 3-member quorum. So I just wanted to share that for those who would come in late. With that, if we can have LAPD come to the table as well. We have a captain that was going to speak on this from a public safety perspective. And then if Ms. Usher, if you could stay at the table as well so we can get your recommended language, that would be appreciated. Morning.
Good morning. Hi, I'm Captain Bill Murphy. I'm the commanding officer of Northeast Area. I've been the commanding officer of Northeast Area for the past 4 years. I also have the senior lead officer, Craig Orange, who's the senior lead officer for the Eagle Rock community here. And Councilmember Jose Huizar had asked me to come by and to specifically talk about...
We have a lot of crosstalk in the room. If we could ask everybody, if you're not here on this item, if you could wait outside if you'd like, if you want to have conversations. The back of the room, unfortunately, it's still a little bit of an echo chamber, and we are broadcasting live as well for those who want to listen in, and the mics pick all that up. And so I just wanted to let you know, if you want to have conversations, you're more than welcome to go out in the hall and come back if you'd like. So thank you.
Okay, and now Councilmember Jose Huizar asked me to come by and to speak, and specifically to speak about quality of life issues that I have seen as the commanding officer at Northeast. In Northeast, we have 47 medical marijuana facilities, and I have certainly, over the past several years, gotten many, many complaints, emails, letters. I've participated in community meetings, and actually single-purpose community meetings on this particular issue. So I believe that Deputy City Attorney Asher did a great job recapping, giving an outline of the complaints, the type of complaints that we get. And I also have the senior lead officer who could give real specifics on the types of complaints, but in a general view, they are quality of life. The residents that live near the medical marijuana, they see ordinance violations. People who may show up there may do drinking in public, or maybe they'll smoke a joint or hang out in their particular area, and this gives them great concern, those type of issues. We also have traffic congestion type issues. As been explained before, they are very, very lucrative, these businesses. They make a lot of money, so there's a lot of traffic. They can tie up parking lots in the area there. So we get complaints about that. We do get complaints about the smell, obviously, from the community. And then particularly in Eagle Rock, I get tremendous complaints because not only is this a quality of life issue, but the state changed the rules on massage parlors. So now we have more prostitution type problems on that. So they're double hit on quality of life issues in that particular community there. So that they're tremendously have some problems with it.
Appreciate you sharing that. I've been hearing this citywide as I go to different roll calls and talk to officers, and it's not in one unique area, unfortunately. And so I appreciate you sharing that as well. And I want to be mindful of the time. I know we've got several other issues before us today as well that people wanted to hear, and so if we could, if Mr. Zine has any further questions on this, I'd like to get Ms. Usher's, the city attorney's recommended language.
Just a
move
couple,
on to this.
Chair, the intended purpose, when I did the motion originally, try and bring some order and regulation to this, it's really gotten far off that initial course with 47 locations in Northeast and all the problems that have been associated. But the intended purpose was to have these locations established for the use of people who needed it. There's been a lot of issues that have come about as a result of litigation, et cetera. There's a couple court cases, and there was an issue that came up Division 3 of the Court of Appeals acknowledges other opinions hold that California medical marijuana statutes are not pre-exempt by federal law. How many courts have come in? I know there's a Superior Court decision. How many different opinions do we have coming from the courts on our ordinance and any ordinance regarding what a local jurisdiction has to do with the California voters compared to the federal law?
So, Councilman Zine, I think you might have been quoting from the Anaheim decision.
It may have been Anaheim. It's just about the third Court of Appeals, the Division 3 of the Court of Appeals.
Very good. So
How many, because I don't want to just specify one. Are there multiple conflicting decisions coming out of different areas in California where this Superior Court and this Appellate Court and this Superior Court, I mean, are they combating back and forth and we don't have a consensus?
Anaheim is a bit of an outlier at the moment. We have, but the short answer is yes. Anaheim, it is difficult, not impossible, but it is difficult to reconcile the Court of Appeals decision in the 3rd Division in Anaheim with the courts of appeal all around the state. It is difficult, it is not impossible, but we are governed by our district, the 2nd District, and our district has been unequivocal that we are preempted, our ordinance is preempted by federal law.
So that's been consistent.
There has only been one case in our Court of Appeal, but it is unequivocal. It is the PAC case.
And then what about the Pura Vida case? What about that case?
That's simply a trial court matter. It has not come to decision. So the way I would look at the Pura Vida case is, Councilman, it is one of the 60-plus cases where litigants have sued the City of Los Angeles and asked that our trial court find that the City of Los Angeles' ordinance is unlawful. There are about a dozen different grounds on which they ask for the court to hold that our ordinance is unlawful. Our trial court has declined so far. However, our trial court's last ruling came simultaneous with the PAC decision. So we have a long road before we go to sleep. We have a long road, and I am here to tell you our ordinance cannot be implemented and it cannot be enforced. So that leaves the City of Los Angeles, from a risk management perspective, in a very troubling position. And when you add to that the 60 lawsuits, you do not have a strong hand, Councilman. You do not have a good hand.
So the position of the city attorney who is here, if he would please take a seat. Well, I have a question for our city attorney, Mr. Kutanich.
Councilman, while he's taking his seat, you are not alone in this quagmire. I did want to let you know that by December of this past year, our Attorney General has concluded that she must turn, and she has in writing, to the state legislature to ask them to re-legislate. So that's in writing. That's the position of our Attorney General. Her letter begins, I think, in a very instructive way. I just want you to hear her first sentence, which is, as the state's chief law enforcement official, I am troubled by the exploitation of California's medical marijuana laws by gangs, criminal enterprises, and others. So our state Attorney General has come to the same conclusion that we have come to, which is Kamala Harris, which is that legislative and judicial solutions at the highest level in the state are essential before municipalities will have a clear direction. And until that happens, you do not have clarity. You only have decisions that say you are preempted, sir.
So here's my question. We have a concern about people who use marijuana at a legitimate purpose for medical purposes, whether it's the pill or smoking marijuana or however they ingest. And I know people who have cancer who have told me personally that this helps them, that this relieves a lot of the side effects of cancer therapy, et cetera. And I think our city attorney in conversations feels the same way.
I do.
So my question is, what do we do, not for the teenagers who want to get high, and I've seen some of the issues that our city attorney has reflected on, and I understand what the senior lead has to go through. Like Mr. Englander, I've served many years in law enforcement and how it has problems in the community, because we've had those problems in the West Valley also. What do we do for the folks, not who want to make a fortune off medical marijuana, because I know there's been a fortune made by a whole lot of people. What do we do for the people who, for legitimate medical purposes, and I think it's a recommendation versus a prescription, how do we take care of those people who really need this because of the illness that they have? What do we do for those people other than saying,
Before you answer that, I just want to, since we have, I wanted to state for the record for those listening in, that we have our city attorney's office present discussing the matter, and now we have the city attorney, Carmen Trutanich, joining us. Thank you very much. And also, before getting into opening up that, I don't know if that line of questioning, and I appreciate it, and we should have the discussion, was agendized accordingly. And so wanted to make sure if we get into those discussions, was that what was agendized for discussion?
Chair, let me turn it over to the city attorney, but before the city attorney speaks, it is appropriate because our ordinance speaks to that question specifically.
So since our conversations have concerned people who really need it, and my initial motion years ago that wanted to regulate this for people who generally needed it and not to be abused as we've seen it, what do we do for those folks now if we follow the rule with the city attorney saying regarding these 60 cases, et cetera, the lawsuits? What do we tell the people who really need it? What do we tell them so they will be able to obtain this and still support what the city attorney's office is asking to remedy this situation? That's my question. Mr. Trutanich.
Thank you, Councilman. Good morning, Councilman.
Morning.
And staff. We spend a lot of time on medical marijuana in our office. And the question was, how much money do we spend in terms of either enforcement or regulating or lawsuits? I can tell you that a substantial portion of our budget, which has been cut severely, is tied up in the 60 lawsuits that we have to deal with. And if it was not for the fact that we have lawyers that spend Saturdays and Sundays and nights, because our staff is limited, doing that work, and they have no discretion, they have to answer, or the city will face a judgment or an injunction or some sort of a deck relief. That being said, we have been careful in terms of looking at this issue with that perspective, that there are people in the city of Los Angeles that truly need a marijuana as a medicine, not to get high, not to make money, but to get well. All right, we are cognizant of that, and we are also cognizant of the fact of what the PAC case has said, and what the judges have said in our litigation. With all that in mind, we decided to the best course would be to have an overall ban until the law was clear, and that was fortified by the Attorney General's letter to me on this issue, that she is actually going back to the legislature to get a fix so that we can have some discretion. Remember, we don't do policy in our office. We don't do, the legislature doesn't, the Attorney General doesn't do policy, she does law. And so when we looked at this, what kind of law would work in the city of Los Angeles? The law that we have put together for your consideration as policymakers would have a carve-out in the ban for just that. And we take out the businesses of marijuana and we leave in the collective as was intended by the Compassionate Use Act. And so we have carve-outs here, and I can go through it, but I much prefer that you read the entire, as Ms. Usher has called it.
If we could go through just at least some of the highlights.
Okay.
So you do have an option.
I'll let Jane do it, but let me tell you, she called it a gentle ban. And honestly, that's a really, really great descriptive term.
There is an option. You're providing an option.
We are providing an option so that those people who are sick, who need this as it was intended to be used, will have the option of being able to obtain it.
And then with the lawsuits, if we go along with what you're saying, what happens to the lawsuits?
The lawsuits are all challenging the ordinance that's currently on the books, which would be repealed and amended by this. And so the lawsuits would all be mooted, and we would ask our trial court and our court of appeal to take notice of your action.
And that would end the lawsuits.
Yes, it would.
As the-
as they exist right now.
Would there be another avalanche of lawsuits because of what we're proposing?
I can tell you with 100% certainty there will continue to be brand-new lawsuits because that's the nature of this industry. However, what we are recommending that you do could only be subject to the most narrow of lawsuits, and we feel very confident based on all the courts of appeal from around the state, that we will prevail.
Has the court, or any judge specifically asked for this type of language, has alluded to, or through inference, or through any briefings filed? Is there anything that has been stated?
There
from the
are-
courts asking for the city to take this type of direction?
Two answers. One, several courts of appeal around the state have said that bans, much tougher than the one before you, complete bans, are legal. They are lawful. Those are published decisions. The second answer, Councilman, our trial court said in his ruling, wherein in October, it's kind of hand in glove, PAC came out and our trial court came out. He said, on his last page, yes, I see PAC. I see the Court of Appeal. I'm going to decline to weigh in today. But I see it, and I see that the City of Los Angeles' ordinance is much like the City of Long Beach's ordinance. So in October, he declined, but I do not believe that he can continue to stand down because this is staring him in the face, much as it is staring all of us in the face. Did you want me to say the highlights of the things that are
Only if you
exempted
feel
from
it's
the ban?
necessary.
I think Councilman Zine asked.
For the people, including me, to say, we're shutting the door, but we do have an option. Other than giving some option, I think it's disingenuous when we're trying to help the people that we say need it, or they say need it.
You got to remember that this is all shrouded by federal enforcement, and that, what we're doing is trying to create a carve-out that that the federal government can live with. We do not want to have our citizens subject to enforcement actions by the federal government for doing something that trying to get well.
Right.
So we are trying our hardest to legally craft an avenue that will be palatable to the feds, given the fact that it's still a Class 1 drug under
Well,
federal law.
then before going into that, would that be more appropriate for closed session, or your?
Yes, I was just about to say I'm constrained, council members, because I can't speak as I would to you in closed session about the risk management and the liability risks to the city from the pending lawsuits.
But you can say that there is an option that we are going to propose if we shut the door.
That's correct. And Councilman Zine, it's the threading a needle. We are attempting to do what I do not believe any other city in the state has done. We're trying to thread this needle by saying we are banning businesses, but we are allowing patients and their primary caregivers to cultivate in accordance with state law. We have 3 provisions where we spell that out in great detail. And it is right in there, and it is novel. I hope other cities will join us in this, what I call a gentle ban. And that's what we are proposing.
It's basically what the initiative came about to say, Compassionate Use Act for those purposes, cultivation, et cetera, a certain amount. That's what we're going back to, the basics that was originally proposed and not words.
Exactly right.
Okay.
Because of our size, Councilman, we have been ground zero in this argument. And almost the entire state has watched what we have done in terms of our ordinance, in terms of where we are at. And we have been following the litigation. This is state-of-the-art in terms of where the law is right at this moment. As the law changes, as the Attorney General is able to go to the legislature and have new things enacted, our gentle ban will be adjusted accordingly and we'll come back to you for policy changes.
So what we want to do is give you the opportunity to have those legislative solutions at the state level adopted and enacted in the city of Los Angeles, but we don't have them yet. So we're trying to make sure that you have a clean slate and that you will have that opportunity when the time comes. Chair, if you're ready, I could go through the list of specifics that
We did have another officer here as well
very
that wanted
good.
to share if we could. And I really, truly appreciate City Attorney coming. Carmen, thank you for coming.
Although I love sitting next to Ms. Usher, I'm going to go back to my standing point, if it's okay with Councilman Zine.
Mr. Carter holding you up over there.
Right. Sir.
Good morning, Councilman. Just want to just pretty much tail in on the previous speaker regarding the nuisance in regards to the area where I actually serve for my constituents in Eagle Rock. More so, it's the fact that it's the juveniles that's a main issue and concern for a lot of the citizens in the area. More so the surrounding high schools that these dispensaries pretty much are located around. You're looking at where kids are actually cutting classes, and then you have also the secondary sales for the actual person who have the actual marijuana card to purchase it, that he or will use another person as a middle person to sell to juveniles. And you have a lot of the loitering aspects of it. And the way school police are working right at this point, they're pretty much inundated with the amount of juveniles for sales around the surrounding high schools for the medical marijuana. Then you have the loitering, plus the rubbish and the trash.
Haven't kids been smoking pot since the 60s?
But it's an issue to a point where you're looking at kids that are 13, 14 years of age and that are actually cutting classes. And you're looking at the actual secondary sales of that particular issue as well.
So is that considered a change from how it used to be before these dispensaries opened?
Correct, to where some of these kids are making major profits in regards to that. So as a whole, for what my complaints are from my constituents is the fact that just the number of sales for juveniles and the amount of loitering in the area is a major concern. To step aside the amount of traffic concerns as well and blocking driveways, and then two, you're looking at people are getting confrontational with some of the residents in the area. For example, I had one particular resident that was coming home from work and his driveway was blocked. And the person who was smoking within his driveway got very confrontational and wanted to actually pick a fight. So when you hit issues like that, there's a major concern for where these dispensaries are pretty much problematic in certain areas such as that.
And you're seeing this, you're talking to other officers citywide, or is this really isolated?
This is more or less isolated within my specific area.
All right. A lifesaver. With that, if Ms. Usher, if you can give us your proposed language.
Yes, thank you.
What you would looking for.
Our recommendation is that you forward our report to the City Council with your approval. And here's what we'd like you to forward. We'd like you to forward our report. We'd like you to forward the draft ordinance. And we'd also like you to forward the accompanying CEQA recommendations that we make that are listed on the last page of our report. As a second step, we'd like you to do the following. We'd like you to refer this matter to the City Planning Commission for its recommendation at its next regularly scheduled meeting, which is January 26th at the Van Nuys offices. And as a third step, we'd then like this matter to be agendized for full City Council immediately following CPC's recommendation.
Okay. Any other input on the change or the recommended language? Then we'll go ahead and move that with an approval from the committee, from the chair, to the, with that language. Moving on, if we could ask Mr. Clerk to get a placeholder on the Planning Commission agenda for that date, as well as an immediate following placeholder for council.
Thank you so much.
Thank you very much. That now takes us back to the first agenda. Mr. Clerk.
Item number 8, motion, Parks Labange, requesting the police department and the city attorney report relative to the department's policies concerning the release from impound of vehicles driven by unlicensed drivers.
I'm going to ask Before I ask the LAPD to come up to present, I'm going to start with the city attorney's office, if I could. We'll wait for the room to clear a little bit from that item. I'm going to ask the city attorney's office to come up only first to give us just a historical overview on how we ended up where we're at, where the state laws first passed, why do we do what we do, what gives LAPD authority to begin with, to impound at all. And so I just want to put on the record that there are no public documents that have been submitted on behalf of the city attorney's office or LAPD to this committee yet. We'll be asking for reports. I believe the motion's asked for reports, but there are no written reports yet. So I just wanted to share that with the public, that there are no reports. There's no CLA report, city attorney report, or LAPD report to review at this time. So with that, good morning, gentlemen. Thank you for coming. Morning. Appreciate it.
Good morning. William Carter, City Attorney's Office. With me is Pete Echeverria, Chief of our Civil Branch of the City Attorney's Office. Good morning, Mr. Chair and other council members and staff. My presentation would be fairly brief in that the council member is correct. We do not yet have a report either from the City Attorney's Office or a final policy or procedure from LAPD, but I'll do the best I can to give you a quick overview as I understand the situation. Under current law, under the Vehicle Code, Section 14602 and other sections, when a police officer encounters a driver, whether it be on the street in a traffic stop or a checkpoint, sobriety checkpoint, the officer can seize that vehicle because they're an unlicensed driver or other types of situations, whether they have a suspended license, revoked license, never been licensed. Or
I don't want to interrupt you, but I just want to state for the record, I believed, or asked the question anyway, that on July 1st, the state law was changed at DUI checkpoints for checking for unlicensed drivers for
January
impound.
1st.
January 1st, I'm sorry. So, is that correct?
Yes.
Okay.
That was Assembly Member Cedillo's bill.
And we've already implemented that with LAPD and
AB
DOT?
353. Yes, it's coming. Well, it's state law now.
Okay.
And generally...
We're adhering to it.
Excuse me?
We're adhering to that then.
Yes. Well, that's what I want to mention. The police have had the authority to seize vehicles and impound them for 30 days, and we do have policies in place that allow that and procedures with LAPD. What happened back in December of 2010, the Los Angeles Police Department initiated a new procedure specifically related to DUI checkpoints. That matter was where if a individual was stopped at a sobriety checkpoint and that individual was not under the influence or committing any other violation other than being an unlicensed driver, LAPD would initiate a policy where that individual could call another person who was a licensed driver or the registered owner of that vehicle, and then that person would have a certain amount of time to come and pick up that car and drive it away from the sobriety checkpoint. Now, that particular driver who was driving without a license could be cited, could be arrested, and he or she could face the consequences for driving without a license or a suspended license or what it might be. But what the difference was how the car was treated, whether the car would be impounded or not. As a result of that change in policy, or excuse me, protocol or procedure by LAPD, and I don't believe at that time the police commission took any particular formal action or not. I'll defer to Mr. Echeverria or Deborah Gonzalez, who is much more knowledgeable on this than I. But as a result of that, Assembly Member Gil Cedillo pursued a bill, AB 353. That bill was passed in last year, and it took effect on January 1st of this year. And essentially what that bill did was created a changed the law, and it's essentially adopted the LAPD protocol as to sobriety checkpoints. And what it did was it modified the law, and the law now says that in such a situation, when a unlicensed driver is stopped at a sobriety checkpoint, then the officers, and the term change, it now says, shall not cause the impoundment of a vehicle if the driver's only offense is a violation of Section 1250 of the Vehicle Code, meaning unlicensed. So the state law changed as of January 1st of 2012 that says officers shall pursue this procedure, and that procedure is if they stop someone at a checkpoint and their only offense is no license, they shall implement. They'll call the registered owner, or they'll call a licensed driver who's on behalf of the registered owner, and that person can then drive the car away, and the car will not be impounded. It's my understanding that in December 13th of last year, of 2010, the Los Angeles Police Department appeared before the Police Commission, and they were proposing either expanding that program or also implementing other procedures relating to impoundment. I know that was heard before the Police Commission. It's my understanding that the Police Commission asked for a final report, or at least a final decision by LAPD as to that procedure. I don't know when the Police Commission will actually receive that report from LAPD. They can answer that beyond my understanding. But I think it is the Ethics Commission, the Police Commission is asking for a return of LAPD for that final report. And at that point, I believe LAPD will outline or specify what their policies will be.
Going back just for a second, just so I understand what happened in the state legislature, the new law, which took effect January 1st, no longer allows impound at only DUI checkpoints. Is that the only part of the? Was there another expansion of the state legislature of the law?
No,
changed in any other the vehicle codes on impound were changed, or was
no?
that?
AB 353 for Assemblyman Cedillo applied only to sobriety checkpoints. And
What
so
happens? I can only guess in terms of some of the theory on that, but I'll take a leap. What happens? And I'm assuming it's because they're set up, LAPD or DOT and others are set up there for a period of time. The officers don't have to have any discretionary decision on waiting any period of time for registered owner, licensed driver to come pick up the vehicle, almost as if it's not causing any harm. Certainly the vehicle would be safe from being any theft or from motor vehicle burglary or any other damage to the vehicle because it's sitting there in front of officers. So I'm guessing that was the theory behind it. What happens when the DUI checkpoint closes down that evening or day and nobody has shown up yet? Is that addressed in the law?
yes, I think there were two reasons for the change, at least as I understood it in the legislative history. The one was I saw some statistics that something in the between 25 and 30,000 people a year are stopped at these checkpoints, and not a small amount, but in the 3 to 5,000 of them are actually found to be intoxicated or driving in the influence. The remainder of those typically don't have problems, but the vast majority of those that are stopped at sobriety checkpoints that are unlicensed drivers, they found were not under the influence. But in that situation, they felt that was one reason why they decided, I understood it, that they would make that change in the law because these drivers' only offense was driving without a license or suspended license. Now, you raised a point, Councilmember, which I think is a good one, and that is when you have a sobriety checkpoint, you're going to have officers that are going to be deployed there for a certain amount of time. You're going to have a much more controlled environment as opposed to an officer finding someone on the street or elsewhere. So what's addressed in the law is they're supposed to give the registered owner or an authorized person for the registered owner a reasonable amount of time to come to the checkpoint. And once they detain someone and they have his or her car, they can then try to reach someone, but it's not unlimited. If that person doesn't get there in a reasonable time and the checkpoint is ending, they're going to impound that car. That's contemplated in the legislation. So it has to, they can give the person a reasonable amount of time, but if the person says, I can't be there in 5 hours, and the checkpoint closes in 10 minutes, well, they're going to impound that car, and that's allowed.
When the RO shows up, if it's the RO, the registered owner,
Right.
or licensed driver to pick up the vehicle at one of these checkpoints, what is the process for releasing that vehicle to that other licensed driver? Do we check their driver's license to ensure that it's valid, that it's not restricted or suspended? Do we check insurance? What do we do to release a vehicle?
Well, I know that LAPD is working on their procedures on that. It's not specifically laid out in the legislation. Those are issues that I know are of some concern, whether there'll be an equal protection argument. And that's why a sobriety checkpoint might be the best place to do this, because at those they may have equipment, they may have live scan, they may have other kinds of time and access to databases where if a person shows up with his or her driver's license, says, I'm the registered owner, or I'm here on behalf of the registered owner, they'll have the ability to double check that. Those are not specifically laid out in the legislation. Those will be things that LAPD and all other law enforcement agencies will have to work out. And those are things that you'll have to, there may be challenges. One agency may say, we're only giving the driver a half hour to get here. Others may say, you got to the end of the...
So I don't know if when we have LAPD come up, we'll ask
They're
if
gonna-
they can speak to the entire process of what happens at the checkpoint, what happens when we release a vehicle now, based on the January 1st change in the legislature. I appreciate it.
Chair, I just want to inform you, it's almost 5 to 10. We need to be in council at 10 o'clock, and there's a lot of information on this, so I don't know if you want to remain here and not go to council, but I'm going to council as scheduled at 10 o'clock. I'll continue it out of respect for the folks that are here. We'd like to give them the appropriate time. I don't think we can do it in 5 minutes.
Well, I can continue. We can continue the meeting, regardless of council. We do have a quorum in council this morning, with or without me. But I'll let you make that decision on your own. There's still a lot of information to go over. These folks many have taken off work.
Well, out of respect
have-
for the
have
folks that are
driven.
here, we do have a council at 10 o'clock. We're required to be there at 10 o'clock. And I would also recommend that we continue this matter, since Mr. Parks, who did this motion, would be able to come here and testify, and he's currently unavailable for council this month due to a medical situation. But out of respect for everyone, I'd wish to stay, but we're supposed to be in council at 10 o'clock. Thank you.
Okay. Thank you, Mr. Zine. And this won't be the last meeting of this issue as well, since we're going to ask for certain reports back. As the city attorney has indicated, there hasn't been anything filed with the committee as of yet. There are no written reports yet. We'd like to see those written reports come back to this committee so they can be presented publicly as well, so we can do this transparently, so we can have every side of this issue heard and input from all stakeholders, which I think is fair. And the other part of that is we're going to ask for some city attorney reports back as well. So there will be some time for that. In addition, I believe the city attorney has just stated that the police commission is also still pending on this issue and waiting for written document and report back from LAPD as they're proposing the change in policy as well. So with that, I appreciate it. So we'll continue, again, the meeting based on that information so we can get through at least the presentations for those folks who have come, and I do appreciate it. You will have an opportunity to be heard because I think that's absolutely critical that you are heard and that you do have a voice in local government and particularly in this issue because it is extremely controversial. It is very sensitive. There are definitely a lot of different opinions, and I have not heard all the opinions on all sides of this yet, and I don't think everybody has. So, and I think it's fair that everybody be heard before final decisions are implemented. As the police chief has indicated, that's what he is going to do as well, is wait to hear until everybody's weighed in on this, so I appreciate that. With that, if you can stick around, we'll ask specific information on what we would like to see come back based on the presentation from LAPD, and I appreciate it. And then before that, Mr. Echeverria, if you had anything, you got dressed up this morning, you're here as well, sitting at the table. Just wanted to see if you wanted to add anything yet.
No, nothing further. Other than that, there is some litigation, as I recall, involving the policy or procedure, and Deborah's very familiar with that. So at the appropriate time, if we get too close to that area, she will.
And I wanted to get into the litigation. I wanted to find out if our current policy, those are some of the questions I'm going to ask to come back in the report, if our current policy adheres to current legislation and litigation and final case findings. Do we have any cases that we've recently argued at all? And what were the findings in that? What were our arguments on behalf of the city on those cases? What were the outcomes? And so we'll get into some of that as well. And then we'll also get into any potential liabilities in changes of policy that could be triggered, civil or otherwise. Appreciate it.
Okay. Thank you.
Thank you.
We'll remain in the room.
Terrific. Thank you very much.
Thank you.
If we can have LAPD come on up. Chief?
Good morning.
Morning.
Mr. Chairman, I ask for your patience for a moment so we can cue the PowerPoint. And as we are doing that, I'm joined, first of all, I'm Assistant Chief Michael Moore, Office of Special Operations. On behalf of the Los Angeles Police Department, I'm joined by Captain Phil Fontanetta, Commanding Officer of Emergency Operations Division, as well as Lieutenant Veronica Matona, Officer in charge of Traffic Coordination Section. And we have a PowerPoint that we'd like to get queued up and provide a verbal report, if you would, and then certainly entertain questions and seek your input. The purpose of our presentation today is in response to the motion that was, it's been earlier described, authored by Councilman Parks, and articulating a concern of this council regarding, or of these, of this motion is information from media reports regarding LAPD stopping the enforcement of vehicle impound policies regarding unlicensed drivers. It is a hope of our presentation today to convey that that is not the purpose or direction the department is embarking on. That our purpose is quite different from that. That we do seek to clarify and inform and provide direction to our personnel in regards to the actions taken when dealing with enforcement actions taken when dealing with an unlicensed or otherwise improperly licensed driver. I draw your attention to the screen on your left and my right. This is largely the presentation that was made before the Board of Police Commissioners that was remarked upon earlier by Mr. Carter of the City Attorney's Office on December 13th. This PowerPoint has been presented to the City Clerk and is available and does serve as part of our presentation to this committee today. And in looking at the vehicle impound protocols and our practices, as a background, what began this process was, about a year ago, there was a report by the Inspector General's office regarding the bias policing complaints and circumstances of our efforts.
Real quick, because I'm not sure if the members of the public have actually seen this. This was not in my briefing package and was not submitted to the committee. And you'd stated it was submitted to the clerk. And so I just wanted to ask the clerk if we ever got a copy from LAPD. So I just wanted to correct the record that this was not submitted.
Okay.
And if we could get it submitted so on the next meeting, we can actually have members of the public review it as well. I'd appreciate that.
Okay. Again, my apologies on that. It's my understanding it was, however, in that it wasn't, we will give you a copy.
Appreciate it.
Forthwith. And again, I'll recall, This was this will, for those of the members that are desirous of looking at it now, this is largely what was presented to the Board of Police Commissioners on the 13th of December and is posted on LAPD Online. Again, back to the presentation, the Inspector General provided a report to the Board of Police Commissioners in December of 2010 titled The Supplemental Review of Biased Policing Complaint Investigations. And within that report and its findings was a situation where the Inspector General identified that there appeared to be some confusion amongst officers and supervisors regarding impounding of vehicles of unlicensed drivers. That confusion was in regards to a multitude of impound authorities for largely the same offense, as well as the fact that their officers and supervisors appeared at times to be unaware of legitimate exceptions to mandatory impound rules, something commonly the role of the community caretaking doctrine and its application in regards to impound authorities. So as the department looked into that concern raised by the Inspector General, we began reviewing our existing orders as well as court cases. The department was aware that the city was involved in litigation involving the Salazar versus Maywood case. That was and the city is a defendant in that case, and it dealt with our 30-day impound practices. We also sought input from the Commission Investigation Division, who's charged.
I don't want to keep interrupting you, but there's a few items that I'd like to ask as part of the record, if we could, as we go along, so we can build the record publicly and be, again, transparent and have that information available to all parties. One is the Inspector General report that you had referred to. I have not yet seen it. It hasn't come to this committee, and it wasn't part of the package. If we can ask for that to be submitted. And then on the Salazar case, as well, and any arguments on the Salazar's case that are a matter of public record to be submitted as well as part of the document, because from what I've heard on the Salazar's case, for example, there were 22 claims and it boiled down to one in the final findings. It was submitted at first as a class action suit, if I'm correct, and the judge kicked that out, and it was based all on one case that ended up, but we filed a lot of briefs on that, wanted to find out, and I believe that was in the Ninth Circuit, and so the outcomes of that and what we submitted as arguments, if we can get that part of the record, that'd be great.
Very well. We also discussed with CID, which is Commission Investigation Division, as to their oversight of our impound hearing processes. We met with various community groups and advocates that are approached by individuals who have their vehicles impounded, and their assistance is sought as to dealing with the consequences of the impounds of their vehicles. What we have come to
on that again, you said you met with various community groups. Have you met with neighborhood councils on this? This is a citywide issue as well, and since it's been an open door policy on this, which is, I applaud you for that, and I appreciate that. In fact, we recently had an extremely controversial, complicated fee increase from the Bureau of Sanitation. They went out and had 76 citywide public hearings and met with regionally with neighborhood councils before making any changes, and we sort of hold that up to a model. And so if you can submit a list of all those groups as well as any, you said community groups, neighborhood councils that you've met with, I'd appreciate that as well.
Yes, in short, we have met with members of community groups and advocates to include neighborhood councils, and we'll be happy to provide information to the council regarding that. As to the protocol revisions, following this review, what we sought to do and what we seek to do is to improve the consistency of our impound operations across the city. As I mentioned earlier, the crux of this is that an unlicensed driver, simply unlicensed driver, the current situation today is that state law vehicle code provides multiple impound authorities. And today, our officers are faced with a dilemma in the street of which of those criteria to use, such as 2261P of the vehicle code, which is for an unlicensed driver, results in an impound and will result in an undefined period of that storage. Yet they can also use for that same unlicensed driver 14602.6 A of the vehicle code, and which results in a mandatory 30-day hold. So the department is looking to, first of all, we wanted to understand state law in regards to this regard, why those multiple impound authorities exist, the underlying purpose of it, and then provide direction to our officers as to what desired enforcement actions we want, recognizing that the severity of the officer's choice of impound section can vary significantly on the driver, as well as the registered owner of that car. The department also wants to ensure that our directions and training and guidance to our officers properly reflect the necessary detail regarding the overarching community caretaking doctrine's existence. That is a doctrine that both authorizes and preempts. It is one that we find is in the public's interest, and as officers exercise impound authorities, however, it's a doctrine that can preempt them from taking an impound where they, by statute, may look at the authority and believe they can. An example of this is an unlicensed driver who is found to be driving a car, perhaps their own, pulls in the driveway of the residence and an enforcement stop occurs. The caretaking doctrine would prevent that officer and preempts that officer from seizing that vehicle. In the decision commonly known as Salazar versus Cornelius, the Ninth Circuit found that, no, it's Miranda versus Cornelius, I'm sorry. The Ninth Circuit found that the seizing a vehicle by the officers has to serve something more than just the statutory authority, that it has to have a caretaking rationale, and that the vehicle in that circumstance did not pose or jeopardize public safety, it wasn't impeding traffic, and that the fact that the officer sought a deterrence by taking the vehicle was not reasonable or sufficient in this situation. And that's, again, I've paraphrased it probably very poorly, but it's an effort to explain the effort here is that the officer's actions in the field is not just governed by what's in the vehicle code, it's governed by the constitutional law and case law. Getting into what this will result in.
If we could, you gave the community care doctrine, the example Miranda case, and the example then that you gave, just for the record, was the very one in this case where they did, in fact, I believe it was a husband and wife driving a vehicle that pulled into a personal parking spot at a home, and the officer impounded. Is that correct?
Largely, yes.
And is it correct that in the Miranda case that we're referring to and sort of using that as a benchmark, if you will, which was stated that under the caretaking doctrine, we're referring to that there were other cases filed along with that at the same time?
I'm sorry, Councilman, I don't understand your question.
In other words, I believe there were 22 original plaintiffs in the case?
No, Councilman, that's a different case.
A different case?
That's Salazar versus
And
Naylor.
this one, though, only dealt with on the Miranda case, the one case where they drove into the personal home?
It dealt with a case of a husband and wife, a wife that was learning to drive a vehicle, being taught by her husband, evening hours. The officer observed the driving of the vehicle, based on the nature of the driving, chose to make a traffic stop. The vehicle pulled in the driveway of the resident's home. The RO of the car is the husband. The husband is licensed. The husband's in the car. The officer took enforcement action to include the impounding of that car. And what happened with the court was that the Supreme Court accepted the deterrence rationale for civilian forfeitures of vehicles that were used for criminal activity. However, the deterrence rationale, which what the city of Cornelius referenced as the purpose for the impound, was to take the vehicle and remove it from the street as a deterrence that it not continue that the unlicensed driver not continue to drive it, that it was incompatible with the principles of the community caretaking doctrine.
Right.
So what it basically said was that, if I might, it basically asserted that the actions of the officers has to take the totality of circumstances into consideration, and that merely the existence of a statute that authorizes an impound does not necessarily trump the totality. There are circumstances such as an unlicensed driver and a vehicle stopped on a traffic stop.
Does the case say unlicensed?
Where a licensed passenger is there in that vehicle cannot be impounded under the authority of simply an unlicensed driver because of the caretaking doctrine.
Okay, I appreciate that. So we'll ask the city attorney then for their input on that, because I don't want to go back and forth on this, I appreciate it. It does have that information in there. It also goes on to say several other things that was unique in this situation because they were home in a secured location. It wasn't on a public street. It wasn't. So we'll ask a city attorney analysis of the opinion, since that's what we're basing it on. But we'll go ahead and move on.
Very good. Thank
Appreciate
you.
it. Thank you.
To the extent of the exercising of this discretion in providing directions to our officers, what we are intending to move forward with is a set of guidelines that provide officers a description of the underlying offense, whether it be a suspended or revoked license situation or an unlicensed driver, and that we will provide them with the actions, direction as to the actions that we're desirous of being taken. For instance, on suspended or revoked licenses, with or without, and this occurs with all drivers. If they're unlicensed in any circumstance, a citation will be issued as appropriate, or a physical arrest, and that is as we do today. Secondly, as to a suspended or revoked licensed driver with no priors, the vehicle would be impounded for a 30-day hold, largely, again, as it's practiced today. If the person who has a suspended or revoked license is driving and has prior convictions for driving unlicensed, then that vehicle will also be impounded, will also be held for 30 days, and is actually subject to forfeiture under an additional vehicle code section. So that is the first, if you will, circumstance. The second circumstance is an unlicensed driver with prior convictions. In that instance, again, we'll issue a traffic citation. Again, the vehicle will also be impounded under the 30-day hold authority. And also, if the person has prior convictions, it'll be documented in the report, because the vehicle is subject to forfeiture under, again, that earlier described section. If we have an unlicensed driver with no priors, and this appears to be the lightning rod, if you will, of controversy, and that is, what do we do with an unlicensed driver with no priors? Well, first of all, in dealing with an unlicensed driver with no priors, the department intends to continue its efforts of sanctioning or taking enforcement actions against those individuals. That enforcement action generally, as it is today, is a citation. However, if the department if the officer is unable to clearly identify who the individual is, taking reasonable efforts, then a physical arrest, as they occur today, will occur in the future. There is no change in our protocols or in our expectations of our officers. Their efforts today, they work through existing department information systems. There are other forms of identification, such as this council well knows, counselor identification cards, such as from Mexico, that are acceptable forms of identification, U.S. military passports, U.S. military ID passports, etc. As the officer is able to identify who this individual is and identify that the person has no priors, then two things occur. One, if there's a licensed passenger there and they are with the registered owner's approval, that vehicle will be released to that registered owner, to that licensed driver. That is actually a requirement within the caretaking doctrine. That is not a discretion. That is something that we need to clarify and provide information to our officers. As we sit here today, while we believe we're in conformance with the law, it is incumbent upon the department that we, in a timely manner, be able to stress to our officers their obligations and the limits of their and the limits of their authority in regards to impounding of vehicles. The other matter of this is that if a licensed driver is not at scene, but there's one readily available, then the department is seeking to allow that readily available licensed driver to come to the scene. Now, readily available, the question has been, well, what does readily available mean? And the department is first of all, looking not to put a time limit, not to say it's 2 minutes, 20 minutes, 30 minutes. Certainly, we do not intend to do the efforts that are currently governed within AB 353 involving DUI checkpoints, which are during the hours of the DUI checkpoint. which it can extend to be hours of times. The chief is looking to provide guidance that will tell the officer that the length of time should be minimal. It is at the discretion of the officer, and it's varied based on the totality of circumstances. And the totality of circumstances means that a situation at 3 in the morning in a quiet street with little work and little other calls for service or obligations of the officer may afford that officer greater time to wait for that licensed driver to arrive versus 3 in the morning and it's New Year's morning. And there are a multitude of calls and there are a multitude of need for those officers. And in that circumstance, 10 or 15 or 20 minutes may be too long. The idea here is that the discretion that the department, we believe we should and can exercise, that we believe we can exercise, and should that licensed driver arrive, then again, the department would seek to validate that person's license and ensure that the vehicle is properly registered and the vehicle would be released. If such a person wasn't at scene, if a licensed driver wasn't at scene or one wasn't readily available, then again, the vehicle will be impounded. The vehicle will be impounded under 22651P. That is an impound authority for an unlicensed driver. That is also the impound authority that is presently used by state law for DUI checkpoints for unlicensed drivers. And again, the chief seeks for us to be consistent, that as you have an unlicensed driver at a DUI checkpoint and the state law and state legislatures have passed, the application of the impound authority in that circumstance is 22651P. Again, we believe that this will add in the consistency of application of what is the consequence, what is the impact of severity on the officer, on the unlicensed driver, but also importantly upon the registered owner of the driver of the vehicle. During DUI checkpoints, again, consistent with AB 353, a bill that was sponsored by Senator Cedillo and it became effective January 1, we will issue a citation to unlicensed drivers. We do that today. This bill largely mirrors and matches the department's efforts that began in March of 2010. As listed, it requires the registered owner or designee must be present or able to respond prior to the conclusion of the DUI checkpoint, and that the release of the vehicle must meet all the conditions, that the registered owner or designee has a valid license, the registered owner authorizes a licensed driver who's not impaired or otherwise unlawfully unable to drive the vehicle, he authorizes that person to drive, and the vehicle's registration must be valid. If the vehicle cannot be released in that set of circumstances, then again, it's impounded.
How long is the impound on that, in that situation?
It does not vary, it does not have a defined length beyond. It's impounded and it's held until the registered owner who is licensed or the unlicensed driver becomes licensed and goes to the vehicle coordinator at the area and gets the vehicle released. So it can be a matter of days, it could be 30 days, it really depends. The vehicle was not released until the registered owner who is properly licensed takes charge of that vehicle, or that registered or legal owner or their agent takes custody of that vehicle.
And unless, what if it's not an unlicensed driver, but a suspended or revoked?
Then the vehicle is held for 30 days.
Under that scenario?
Yes. A suspended or revoked licensed driver is actually also subject to the caretaking doctrine, depending on prior convictions or lack thereof. And so similarly, but in our general practice, our general protocols, suspended, revoked licenses, unlicensed drivers with prior convictions will suffer a 30-day impound.
But, so under a suspended or revoked license, just so I'm hearing this clearly, so I can understand it, and everyone else can understand it, you're suggesting that the policy that will take effect will be at a DUI checkpoint. If it's a suspended or revoked license, they too will be subject to the community care doctrine allowing and waiting for a registered owner or licensed driver to pick up that vehicle?
Absolutely not. I'm sorry. I'm not being clear. A suspended or revoked licensed driver who's stopped during a DUI checkpoint, and their vehicle will be impounded and held for 30 days. If there was a licensed passenger there who's a registered owner of that vehicle, and without prior, this suspended or revoked license doesn't have prior convictions, the caretaking doctrine, as I understand it today, would provide for the release of that vehicle, and I'll look to the city attorney's office for that finer detail.
I'm sorry, if you're saying there is a licensed driver present,
Yes.
or, yes.
At a
Yeah,
suspended or
What I
revoked.
wanted to clarify, Councilman Englander, is the community caretaking doctrine relates to the Fourth Amendment seizures of any property, including vehicles. So that really is what determines whether or not the impound is reasonable under the Fourth Amendment. From there, assuming under the totality of the circumstances, the impound is reasonable, then the department can, as a matter of its own procedures, operations, policies, whatever you want to call them, decides that it wants to give more opportunity, then it can do so. But the two shouldn't be mixed up with each other.
Gotcha.
The community
Baseline to
caretaking
look
is the
at
baseline.
as a
Exactly.
guide, not a rule, just as an understanding. And so, just to be clear then, what is our current policy at a DUI checkpoint, not for an unlicensed driver, because you've covered that well, and I appreciate that, but for suspended or revoked? What's the current policy and what's the proposed change in policy?
There is no change in policy or protocols or practices regarding suspended or revoked licensed drivers at a DUI checkpoint. The practices today will continue. This means this effort that we're going with, this special order that's being developed, is meant to describe field encounters, traffic collisions, and efforts involving DUI checkpoints as a document that is whole, that is not splintered in various sources and found in various locations, but that offers guidance and direction to our officers so that it can be a complicated subject that can be more easily digested and and consistently applied across the city. A suspended or revoked licensed driver in a DUI checkpoint will generally have their vehicle impounded, with rare exceptions. The exception would be without prior conviction history if they had a licensed passenger with them. The department intends to afford no discretion or offer no leniency in allowing a licensed driver to be summoned to the scene, nor did AB 353 intend to do so, as it clearly indicates in its language that really was really matched or followed the department's earlier implementation, that the allowance of having a licensed driver come to the scene was strictly limited to an unlicensed driver, not these other situations where a person's license has been revoked or suspended.
Okay, and so it's strictly on an unlicensed driver at a DUI checkpoint or in other cases?
For AB 353, yes.
Okay. And then on the unlicensed, I'm just trying to get it all, digest this. It's a lot of
Well,
information.
if I might just finish this and get to your concerns, if I might? Sure. Okay, so during traffic collisions, which is another prong here, officers will, again, if they come upon a property damage only traffic collision involving an unlicensed driver, currently, we take, with no injuries, we will take a traffic collision investigation. We cause both parties to exchange information. We inform the party that was involved in the collision if the other individual is unlicensed, and that private person can make a private person's arrest of the unlicensed driver. The change that will occur is that we will no longer take a collision investigation. We will instead direct the officer to take enforcement action against the unlicensed driver in the form of a traffic citation. And we will, however, continue to inform the other involved party that the driver who's unlicensed is subject to a private person's arrest based upon the private person being able to articulate that the person was driving and was involved in this collision. In the circumstance involving a traffic collision with an injury, there's no change. A collision investigation report is taken and enforcement action is taken as it is today. Finally, implications. There have been concerns that have been identified as the implications on fees and taxes associated. The impounding of a vehicle can vary in severity upon the driver or the registered owner. A one-day impound with fees and taxes will amount to approximately $200 to $250. A 30-day impound will exceed $1,300 in fees and charges. For the city, it gathers administrative and taxes within those amounts gathered, and they're listed here where the vehicle release fee of $115 on each impound, a tax on the storage of 10%, a franchise fee of an additional 7%.
Okay. Going back to, I'm sorry, just we glanced over it pretty quickly, and since I didn't have the PowerPoint as the record, I'm sorry for asking for so many questions on just trying to figure this out. If we can go back a slide, you'd mentioned that if there are injuries, I mean unlicensed, suspended, or revoked, right, that we'd absolutely impound if there are a traffic collision with injuries.
I apologize. I actually didn't say that, but if their traffic collision involves injuries, existing and future efforts direction will be for traffic collision investigation to be taken. So if you have a traffic collision today and someone complains of injury, the department completes an investigation, completes a written report. That happens today. It'll happen with the implementation.
No, but my question was, though, if it's an unlicensed, revoked, or suspended driver.
Yes.
In a traffic collision with injuries.
Yes.
Will that vehicle still fall under an ability to release to another RO or licensed driver, or is that an impound?
Well, if the vehicle is incapacitated and is posing a traffic hazard, it falls under the community caretaking doctrine, and it'll be impounded. I would say that if it's an unlicensed driver, traffic collision, no injuries.
We're talking about just with the injuries. I'm just trying to get this. Yeah, clearly, with the injuries, is there a situation or scenario under what's being proposed that says, if I can read from the document, unlicensed driver or driver with suspended, revoked driver's license involved in a traffic collision with injuries, the action taken shall be to release the vehicle according to the appropriate unlicensed driver or suspended, revoked driver's license sections.
It goes to the underlying purpose of the impound. If, for instance, you had a vehicle involved in a traffic collision involving injuries where the unlicensed party was at fault. If there's an evidentiary value of that vehicle is involved per se in a vehicular manslaughter, or was involved in running a red light, and it was a party one, and the role of that vehicle in that, the driver's actions, which would be criminal or could amount to being criminal, then the vehicle would be impounded not actually under an underlying authority that we've talked about here, but under an evidentiary authority. What Lieutenant Katona talked about is what we're encouraging our officers is that generally with a traffic collision, if those are many times the vehicles are incapacitated, they form a traffic hazard, they can't be legally parked, and those vehicles then are impounded. However, if you had a circumstance where the vehicle could be lawfully parked, it was still operational, but you have an unlicensed driver, then today we would complete a traffic collision investigation and we would ask for an application, we would appeal to the city attorney to present the case for them to consider criminal filings against the driver, the unlicensed driver, or the driver with the suspended or revoked license. What we're providing for here is we're going to strengthen that, where if it's a suspended and revoked licensed driver or an unlicensed driver with priors, then the vehicle will be impounded because of the unlawful operation. If it is a simply unlicensed driver with no priors and the person will still be cited, but the impounding is not automatic. It needs to meet the totality of the circumstances. It needs to meet a caretaking function and not simply be punitive or some deterrent, be served to some officer's idea of a deterrence that would keep the person from driving in the future.
So if an unlicensed, suspended, or revoked driver, just so I'm clear, gets into a car accident, and again, you say meet the community care doctrine. It was always stated that that's a guide, not a rule.
No. It has to be complied with because...
Certainly.
Under the Fourth Amendment.
If we can have that as
So-
part of the record, I'd like to have that doctrine submitted to the committee as well.
We can explain that as part of our city attorney report.
But can we actually have the entire document submitted?
What document?
One you
The
referred to
community
as-
caretaking
the
doctrine is a
definition.
legal doctrine that has come from many, many, many cases.
If we can get an overall highlight
what
of
I'm
that.
saying. We
Yeah,
could put
submit it.
that
That
in
would be
the
great.
report
Okay,
for
appreciate
you.
that.
Yeah.
So the question on that, though, is, unless it says otherwise specifically in that doctrine, and again, that's a baseline, or unless we can point to specific case law that's binding, I'm trying to find out where that's coming from. Is there a legislative change in that, where if there's an unlicensed, suspended, or revoked driver who causes a traffic collision with injuries, it's not an automatic impound,
Again,
which is a
Let-
change
let
from
me-
what
let me
is
focus-
occurring today.
if I might focus, that our enforcement action regarding traffic collisions, as to the impounding of a vehicle, for instance, the impounding of a vehicle is a seizure, can't be, is really, as I understand it, not an enforcement action. You're seizing the vehicle because it's impeding traffic or posing a hazard. We don't look to, or not desirous of changing the manner in which we deal with collisions that are causing injury as to what we're currently doing with those vehicles, except to be consistent with the law and in compliance with the law, with case law, particularly the community caretaking doctrine, and then the application of the underlying authorities.
Right.
And the underlying authorities, for instance, on a suspended or revoked licensed driver involved in a TC would result in the impounding of the vehicle. If it was if it's an unlicensed driver with priors, would result in the impounding of the vehicle. Both of those situations for 30 days, because the person's unlicensed with priors,
What's the reason? What are some of the reasons for having a revoked or suspended license?
Driving under the influence, reckless driving, those are two circumstances that immediately come to mind.
Could it be as simple as you go to renew your license and you failed the eye test?
On a revoked license?
Suspended. I said revoked or suspended. Can you have your license suspended because you just didn't pass the eye test?
Well, again...
They just give you a license anyway, even if you don't pass?
They just wouldn't give you a license.
They just wouldn't give you a license?
But
If you currently have a license and you go to renew it, and they say you need corrective lenses, you didn't pass, you need to have a doctor's letter that you've gotten that and come back, what happens? What is that considered?
if you don't renew your license,
If you go to renew your license,
and you can't,
which a lot of seniors do,
your license will eventually expire, and then you'll be have an expired driver's license.
okay? And so an expired license falls under what then?
Go ahead.
Well, as to the vehicle code, and this becomes can become complicated because the underlying purpose of the suspended license comes into play. There are circumstances, as I understand it, for instance, of a failure to pay child support that can result in a suspended license. Those are different, and the vehicle code talks about its application of impound authorities about those circumstances differently than a suspended license for reckless driving or suspended license for being habitually DUI. Again, perhaps this might be a matter that, rather than responding to you verbally, we would give you better detail in a written report as to circumstances of an unlicensed driver, because they're, as you say, they're not uniform. They vary as to the underlying reason. You can be uninsured, for instance, that will result in being a suspended or revoked license. That, again, the code lists details within the section as to the efforts of a 30-day impound being warranted for a suspended or revoked license if the suspended or revoked license is under these circumstances. And then it says it's not on otherwise. And the same goes for vehicle forfeitures as we understand it. There are vehicle forfeitures that can occur with a prior misdemeanor conviction, but again, it has to be within the confines of what's laid out in the code. Again, Councilman, that's the essence of the department's efforts here, is as we look across the vehicle code and its applications. First of all, it's not strict. Its applications afford officers and the agencies the authority to take action that are then are subjected to their reasonableness, because the impound is a seizure under the Fourth Amendment. And so while we have a toolbox in front of us of impound authorities, we have to be clear that those authorities are not without limits, and they have to be in totality, they have to be reasonable as to the Fourth Amendment seizure, and as such, that's where the caretaking doctrine gives guidance and direction. And what our efforts today, largely in this effort, and why the chief is desirous of us moving forward on this special order, is we need to explain this to our officers. We need to explain this to our supervisors, because about a year ago, a little over a year ago, complaints from the community is that the application of our impound practices today are not consistent, that we have different
without getting into the
different
editorial
authorities
part.
used by different officers, or the same officers.
I get it's coming from a lot of different directions. So
So
I agree with you. To spell those sections out in a written report would be extremely helpful.
Very good. And then, as we talk about the implications, there is a possible consequence in regards to as our 28,000 plus vehicles that were impounded this last year for 30-day holds. Some 43% of them were released prior to the full 30-day impound as a result of mitigating circumstances, which is provided for by the statute. As the department has been asked and by some stakeholders, what will be the impact on OPG revenues, what will be the impact on city revenues, we cannot respond with certainty, because presently we have impounds that are done that vary, again, from 0 to 30 days or beyond.
Well, this is the Public Safety Committee, not the Budget and Finance Committee.
I understand that, but
appreciate
in being complete with you, and also in the discussions that were discussed as we have sought to address various stakeholders and their concerns, I wanted to address it. The other aspect that was brought up was how are we going to implement this? And the reality of simplifying and clarifying for our officers our direction as to what authorities we are desirous of them using. Is we do intend to have, in our developing messaging, whether it be the chief of police in his video messaging, standardized roll call training, production of frequently asked questions, many of which you've asked earlier, and I anticipate you asking here in a few moments, as to give answers that are in the affirmative. We recognize today that officers in the field are looking at and hearing these proposed protocols, and there's confusion. We seek to get this matter closed, to take input from all parties, to have it influence the protocols exercised by the chief, but to move forward by giving our officers certainty as to quick reference sheets, roll call training, frequently asked questions, and also finally, the community. That the community should be able to anticipate from the Los Angeles Police Department that if they are unlicensed or have a restricted license or otherwise improperly licensed, that they understand what the consequences will be. When that's done, I believe will be an improvement. While I believe our actions today are lawful, and we certainly would argue fervently that they are lawful, we believe that this proposed change in protocols will add consistency, will add appropriateness in the sense of discretion as to the severity of the underlying offenses, and that this will be viewed by the community as fair and in the public's best interest. And I certainly look forward to any questions.
Great. Thank you. I appreciate that. With that, why don't we just ask for a report back on a few things? And I know you want to move on this pretty quickly, and I appreciate all your time and input and effort in this. It is complicated. And as you pointed out in just going through the PowerPoint, there are so many different scenarios. And I think, and it's we have the best police department, bar none, in the country. We're experiencing 9 years, I believe, in crime reductions in a row. We are one of, if not the safest city in the United States, and I think one that tries to treat everyone fairly and errs on the side of caution, is constantly adopting and adapting its policies and procedures to reflect that. I think the department has done a tremendous job in not only the training, and the training that I've gone through, to be sensitive to all residents and throughout Los Angeles, but also to be a reflection of what LA is made of today. And if you look at the men and women the racial diversity of the department, it is a true reflection of Angelenos today, and I compliment the department on everything they've done with that. To adhere to the consent decree and to get out of it, to focus on not only all of those efforts, and if we just look back a decade ago, this was not a department that was widely respected by its residents. I would say today it's a complete change and reversal of that, and that's because of mainly the 4 of you sitting here and the 9,000 plus behind you.
Nearly
And-
10,000 plus reserves,
and the
including
reserves as
yourself.
well. We'll point out that it was the sheriff reserve that caught the arsonist, but we were right behind them, weren't we? But having said all that, I appreciate that you are trying to make a strong effort. I've said on the press, and I'll say it again, I absolutely disagree with parts of this policy, not the totality of the policy changes. And that's what we'll get to try to figure out in writing, and so we can examine those and ask questions and deal with the scenarios. There are a lot of questions being asked by, when you say the community, and the community supports a lot of these changes, it depends on which community. We have a lot of communities throughout Los Angeles, and we have to address all of their concerns equally, so I do appreciate that. Just a few things we'll ask for, in addition to what was asked for already, is just a few things on, and we can get into some of the scenario things when this comes back in a written report in terms of what does readily available really mean in the eyes of the law, in case it's challenged, things like that. But outside of that, I do have one other question before I get into that, actually, on the questions of a licensed driver showing up or a registered owner showing up. Do we have probable cause, or do we have the ability, or do we check their license when they show up to take that vehicle and make sure it's not revoked, suspended, or there's no wants or warrants? Or do we simply say and look at their prima facie, they got a driver's license, go ahead and take the vehicle, here's their certificate of registration or insurance? Or do we actually have cause to check them before we release the vehicle to them? Wasn't sure about that.
Councilman, you have a tendency to ask compounded questions. The basic answer is that in releasing a vehicle to a person who arrives and is licensed, who presents themselves as licensed, we check and can lawfully verify that they're suitable, that they have a valid license. We do so on scene. I want to correct the record as to earlier, Mr. Carter identified that during DUI checkpoints that he referenced what we would have as live scan on scene. The department does not have live scan on scene at DUI checkpoints. What we do have on scene at DUI checkpoints is largely the same things we have on scene at a field stop, which is we have our department mobile digital computers, which have access to a host of information databases to include DMV. We also have blue check devices, which can take a fingerprint and can identify an individual while in the field positively based on their prior history. And so as a person presents himself as a licensed driver to take custody of an unlicensed driver's vehicle, with the registered owner's permission and with a valid registration, our officers could and do check the status of that driver's license to ensure that it is valid.
Okay, thank you. And yes, they're compound questions because they're complicated questions. With that, so we're going to ask the city attorney to report back on the current laws governing LAPD's ability to impound, the historical elements on that. Does LAPD currently violate any impound policy in the state legislature or with the courts? Are there any conflicting recent court cases that suggest right now that we are out of compliance with? And I'd like this from the city attorney. I'd also like from the city attorney an analysis of liability in terms of civil liability with any suggested changes to these policies and procedures by LAPD. Does this expose the city up to any liability in these changes, and what might those be in terms of liabilities? Also getting into, I think I've covered liability on LAPD. I'd also like to know if from the CLA, and I didn't have a question in here, but I would like the CLA to respond, or the city attorney can do this as well, to look at current legislation and any conflictions. It was stated earlier that we are inconsistent with current law, as the chief had stated in his remarks. And I'd like to know exactly where, from the city attorney's perspective, we're inconsistent with current law, and to define that, since it was stated, because I haven't been able to find that. To follow up on the articulable facts from LAPD and when in their presentation, if they can show, it was stated that they must have articulable facts. What would those be for an officer to write? What particular articulable facts to show reasonable time? It was stated that there has to be a reasonable time for either a registered owner. I'd also like to point out that I saw some cadets walk into the room and applaud them as well. I'd like to see our cadets in blue always participating. So if we could recognize our LAPD cadets. But with the articulable facts, what would they have to articulate in the report to show what reasonable time is and how an officer would...
Sorry, Councilman, reasonable time in regards to DUI checkpoint?
No, I'm sorry, regard to, because I think you covered that. The reasonable time was when the DUI checkpoint basically closed down.
Yeah, and I'm sorry.
The reasonable time to allow another, either the registered owner or driver's license, valid driver's license driver to pick up the vehicle, it was stated that they should wait a reasonable time and not define the time.
If I might clarify, just so that your question can be, we can better respond to your question, because we are not directing our officers to wait a reasonable time. We're directing our officers to that if there is a person readily available, and we define that to be the length of time, is that it should be minimal and that it should be at the discretion of the officer. We do not use the word or use the phrase that the officer wait a reasonable period of time.
So if we go back to readily available, what, if we could just have a brief description, which I'm sure you would have in the order anyway, on what the officer would have to document showing that they were or were not readily available. So in other words, if an officer calls for an impound and states on their report that there was no driver readily available, I'm assuming they should have some articulable facts to back that up. What types of facts are you looking for? So if and when this is actually implemented, the officers are fully aware, and then from a liability perspective, when we're sued, which we probably would be, since one person felt there was a driver readily available, they were coming across town, it was traffic, it was going to take him 3 hours to get there, and that was reasonable. Where the officer says that really wasn't reasonable, there was a large call load, we had shots fired, we had other things going on, we had to respond in OIS, and so the question is, what would then the officer have to document on the report to show that they felt they met that criteria? Does that make sense? Okay. I'd like to see, it was stated throughout that we would determine if the unlicensed driver had any priors. And I don't know, I'd like to see in the report how we track an unlicensed driver having any priors. So I'd like to see that documented as well, and how we track that now to determine if an unlicensed driver has been cited in the past or not, and even if they've been cited, how does that what did they make that determination on, and cited for what? Is it cited for anything, or they've just been cited? And it was stated that if they had been cited in the past, it falls under a whole other category. So trying to find out what that means and how we track the fact that if they don't have identification here, if it's perhaps somebody visiting from another country with a passport, and they've been cited in the past, but they wouldn't be in the DMV file, how would we ensure that that's really that person? So if we could document that as well. And you'd stated the acceptable forms of ID pertaining to that, so that would be included in that as well. The one last thing, if we can look at, or near to the last thing, the registered owner. If a registered owner repeatedly lends their vehicle to an unlicensed, suspended, or revoked driver, how do we track that? I'd like to see that in the report as well. If a registered owner repeatedly, on more than one occasion, or has in the past, lent their vehicle to unlicensed, suspended, or revoked, how does an officer track that or look that up in the field? And so I wanted to know that as well. That's critical. And I think that concludes what we would ask for at this point in a written report to come back. My question to you is, I'm willing to schedule this because I know you want to move on it as soon as possible. And so you tell me when you think is reasonable from LAPD. We have Chief Pasinger here as well, wanted to say hello. If we could state what's reasonable to come back with the written report, answering all those questions as well, and also from the City Attorney's Office, how much time would you like?
Well, as to the Police Department, our report will need to come through the Board of Police Commissioners to be forwarded to this body, to this committee. So I'd anticipate that we would need 6 weeks in order to do that. In regards to reporting providing the information you've requested.
And that would be readily available?
I'm sorry?
I said it would be readily available. Sorry. Okay. Then 6 weeks, and we'll schedule it for.
And I can't respond for the city attorney.
Oh, of course.
To that.
6 weeks, is that reasonable? Yes. Okay. So we'll go ahead and tentatively schedule it for 6 weeks, and I say tentative because we'll wait on your watch for your opportunity to spend the necessary time and go to the police commission first as well, and that may or may not occur exactly within that window. But I also wanted to get on the record that it has been stated, and I just wanted to put it out there and ensure we're all on the same page, since we are going through this process, and it's a process, that it was stated, well, I read in the press, so we'll get it out there, that no orders will be implemented by the Los Angeles Police Department until this has had its opportunity to come to the full council.
Well, Councilman, I can assure you that no order will be implemented until it's been brought back before the Board of Police Commissioners. That's what was following the December 13th, 2011 presentation. I know that, and on behalf of the chief, he is desirous of seeking input from this council and its feedback regarding these protocols that we believe as a department are within the expectations of the chief to administer. And I will certainly go back and speak with him regarding your desires that the full council.
The statement that the chief had made in the written statement was that this won't be implemented until it's had the opportunity to come to the city council, to be shared with the city council, the full city council. So I will
convey to him that information.
Get that understanding as well.
I will certainly convey to him that information.
That'd be the wishes of the chair, and from talking to many of my colleagues as well, their wishes. So thank you. There's that I think concludes, unless anybody's got anything further. This agenda, we still have another yet special agenda item, and I appreciate everybody's time on that.
The second special meeting, item 1. Board.
Unless anybody's got any comments on that, I think we'll go ahead and move that on consent.
Very good.
Right.
Item 1 is approved.
Okay. That will adjourn all 3 meetings of the Public Safety Committee. Thank you.